Hey, welcome back. Now let's talk about the new prisons reform. President Buhari on Wednesday signed the Nigerian Correctional Service Bill into law. The bill, among other things, changes the name of the Nigerian Prison Service to Nigerian Correctional Service. President Buhari had previously declined to sign the bill back in April after lawmakers, presented it to him. At that time, he declined because he said, on the grounds of that some of the provisions violates the Section 81 and 84 of the Nigerian Constitution, which guarantees the independence of the judiciary. So we have in the House this morning, we have a legal practitioner, we have someone from the Prisons Fellowship of Nigeria. Let me quickly introduce the Executive Director of Prisons Fellowship of Nigeria, Mr. Benson Iwagu. Thank you so much for joining us this morning.
Thank you.
We also have a legal practitioner, National President Committee for the Defense of Human Rights, Mr. Malaki Ugumadu.
I'm delighted to be here. Thank you.
And in our Abuja studio, we'll soon be joined by the founder, Executive Director, Prisoners Rehabilitation and Welfare Action. But before then, let me ask Mr. Ugumadu, what do you think of this, the change in name for the Nigerian Prison Service and generally this reform coming at this time?
It speaks to the need for some shift away from punishment to, as it were, correctional prison services. Clearly, in recognition of what prisoners or ex-prisoners are to the society ultimately when they have served their prison terms. So to that extent, it's a welcome development. However, the robe, they say, does not make the monk. We have toyed with a lot of changes. There were moments when we talked of changing the entire police from Nigerian Police Force to Nigerian Police Services. Since this bill was assented to, the consensus out there is that, please, we must do well to focus on the factors, the objective factors that will affect these corrections, much more than merely changing, the name, which is deals with the nomenclature of the facility.
That's just one of the provisions.
Correct, but it has taken the shine, as it were. So, what do you do about the capacity of prison officers? How do you empower the inmates themselves? To what extent are you going to guarantee that the infrastructures and facilities that will occasion that reorientation, that reform? Indeed, in other developed climes, it is called the penitentiary, which is another word for that correctional. But not much is different from what has been coming in piecemeal. As I speak with you now, people who are standing trials are no longer called accused persons under our laws, both under the Administration of Criminal Justice Act and the Administration of Criminal Justice Law. There is enough done to not just humanize, but de-emphasize punishment, as it were, having regards to the fact that ultimately the whole essence of this process, this package, is to guarantee that the people become a better people for the society and are able to add value to the same society that they have run foul against. So it is a welcome development, but I think that the emphasis must be focused on providing within the prison facilities those needed and desired infrastructures that will guarantee that correction that you want to effect.
Okay, let me quickly go to Abuja. I'm the founder and executive director of Prisoners Rehabilitation and Welfare Action. Uju Agomo is there. Thank you for joining us this morning. Quickly, aside from the name change, from Nigerian Prisons Service to what it is now, one other provision of that law is that a prison or the controller, the state controller of prison can actually reject, you know, prisoners or anyone that is being taken to that center based on the fact that the capacity is already, you know, fully booked. What do you think about this reform?
Yeah, first, thank you very much for having me. First, I must say before I answer this, there's a whole lot of things beyond just the name change that is reflected in this piece of legislation. And it's important to stress the fact that what we are having as Nigerian Correctional Service includes both the custodial and the non-custodial service. So what that means is that the prison, as you and I have always known it, the Nigerian Prison Service, as you and I have always known it, is the custodial service. But in addition to that, there is then the inclusion of the non-custodial service, which is a new ballgame, and there's a whole lot of changes now beyond just the name. So I think there's a whole lot that Nigerians need to celebrate about. Now, the point about the question regarding ability to reject, and this you see it in Section 12, subsection 8 of the Nigerian Correctional Services Act 2019. Clearly, this is a very welcome development. The reason is that that particular provision now makes it possible for the Nigerian Correctional Service to now play a more active role in determining what happens in terms of prison congestion, in determining what happens in terms of the persons who are kept in the prisons. Subsection 4 or that section 12 says that the state controller of correctional service, in conjunction with the superintendent in charge of the custodial center, when they notice that the population is exceeding the capacity of the facility, has within 1 week to notify the following persons. 1, the chief judge of the state, the attorney general of the state, the prerogative of mercy committee of the state, the criminal justice committee in the state, and every other relevant body that will have a role in playing in regards to this. Subsection 5 of the same section 12 begins to now say that in terms of the FCT, the person that needs to be informed is the attorney general, as well as the chief judge of FCT. The next subsection, which is the subsection 6, now begins, section 6 begins to now say that in respect of the whole country, that the Controller General should inform the Federal Attorney General and the Chief Justice of the Federation. Now, it's also important to say that once they have been informed, they have 3 months to be able to activate any process to ensure that that population is gotten down. Now, it is only when the expiration of the 3 months have happened and the due notification have happened that the officer in charge, in conjunction with the state controller, can say, no, we are not taking it. Now, let me tell you what that will do. What it then will do is that it will force the others, including the police and the, to also ensure that they will only use that facility for what it is. So you can't just get minor offenders, petty offenders, people you have not ready to, to take to court, and just dump there and wait for 10 years or more going forward. It also, so it has a kind of check and balances. But whoever is also rejected, there is also due process in terms of documentation. So I see this as a very, very, very important role and input that this new piece of law is going to help us to achieve.
All right, brilliant explanation there. I guess provide some, shed some light on the issue. All right, but we also know that there's some level of information sharing in this country in certain terms, but we also understand that people have information, but at times they simply can't do anything about it. If we have a certain number already, our prisons are congested, you can't just, everybody knows. For instance, those people that you have mentioned, if they know you can't take somebody to Lagos now, you can't take somebody to Abuja, but there is somebody who needs to be taken somewhere, which speaks to the issue of funding and budgetary allocations. It also means that we may have to build more prisons. Is there any part of this new corrections to the legislation that takes care of ensuring that monies go to the places that they need to go to?
Yes, I mean, I think, I would just give you some few instances. Remember that the part 2 of this piece of legislation is all about non-custodial measure. So fast forward, what this name means is that all those minor offenders, all those persons who the Administration of Criminal Justice Act and not so many other Administration of Criminal Justice laws of various states have captured to be the kind of persons that should benefit from non-custodial measures, would immediately divert to that process. So why should the government be paying for feeding of persons who can be in the community serving or doing something for, in terms of sentence? Now, once that goes off, remember that there will be a way of saving certain spaces. So it therefore means that minor offenders will no longer be kept in those facilities. This particular piece of legislation also sets something very critical in terms of the standards of human rights compliance, the ventilation, things around space, and all the rest of that, in terms of whichever place that needs to be designated as a custodial facilities. There are things that have also been spoken to in terms of the law, in terms of the proper designation, and I think I may spend a little time explaining what this means. Proper designation of the various custodial facilities. Now, from maximum, medium, and then down through. The reason this proper designation is because it's not just by saying this is a maximum security prison or a medium security prison or an open prison facility or things like that. We want to make sure that even the things around the treatment, the programming, the security needs and risk, and including the security gadgets for the prisons are reflective of the security graduation of the particular prison as so designated. That is also provided there. So you will find that issue about accommodation is also taken care of. Now, I want to explain very critically that in Section 34 and Section 35 of the law, Section 34 of the law tells us that every state should have a separate facility for women prisoners. Meaning that now we would remove the possibility of having mixed prison because you and I understand the risk that encounters. While Section 35 now talks about the fact that in every state there should be a BOSTA, a young offenders facility. Why is this important? At the moment, we have young offenders facility in terms of BOSTAs only in Kakuri, Kaduna, Ilorin, and Abeokuta. Some of the states, by virtue of the Child Rights Act, are supposed to provide remand homes and approved schools, but that's not at the same level. But now, what is then happening is that with this new measure that have been provided, you find that young offenders or underage will no longer be put in adult prison because it has implications. So, back to your question, what is happening about the space? You understand now that you would have no need to keep people who don't need to be in prison. And please, let me stress this. People need to understand that it's not everybody who is in prison that have committed offenses. Of course, there are persons who have committed absolutely no offense. For one reason or the other, they are there, which is the reason why we need to quickly ensure that they have legal aid services or legal services to ensure that those who don't need to be there, don't need to be there.
Let me bring this discussion back to the studio. Mr. Iwago, one of the provisions states that correctional service must initiate behavior modification in inmates through all the provision of medical, psychological, spiritual, and counseling services for all offenders, including violent extremists. How well do you think this is going to make a difference in the life of, anyone that finds himself or herself in these correctional centers? Looking at, the challenges we have with implementation, because there are laws, but implementation is the key thing.
Your question goes back to the point earlier raised by your colleague as to funding. All things are possible if you have the funding, because to identify the causative factors of crime, there are specialties, there are specialities, there are specialists, there are structures, there are stages. So everything is possible, okay, to achieve that aim or the objective of ensuring that treatment appropriate for reformation is carried out. But again, you go back to the sentencing process that lands the people in the correctional center itself. Because diagnosis is important, whether in medical or even in behavioral dysfunctions or disorders such as we have. Some are there, could be genetic, some are there, could be substance abuse, some are there, could be environmental factors that induced or predisposed them to those crimes. You agree that this is not something that can be done knee-jerk or ad hoc. It needs a well-established structure. But we must accept and acknowledge and commend the president for signing this bill into law. So where it is possible, but we must go back to the sentencing point. We've talked about custodial and non-custodial. Who determines who go to custodial and who goes to non-custodial? What are the parameters? What are the issues that you have to look at? So for me, I think this is going to call for consequential amendment, not just the Prison Act now, even for the Constitution. For instance, in Section 43 of this law, where it talks about the non-custodial sentencing or this non-custodial outcomes, which speaks to restorative justice, a very important aspect. Who determines and what kind of court system? And that is where I think we must be minded to provide the system that delivers. You have outcomes in those sections, but the system must be right.
Quickly, before we take this break, just so our viewers can follow us even better, explain briefly what the custodial and non-custodial services
Now, custodial means an offender has been tried, convicted, and now the judge or the court came to the conclusion that this convict, because of the circumstances of the crime and all that, needs to be put away from society to protect the society from him and him from the society. That's one. So there is a reason, and ordinarily it should be people who are high-risk offenders. That is not presently the case. Why? The courts are congested. Now, non-custodial talk about those outcomes that relate to people serving those sentences from their homes or rehabilitation centers or vocational centers. And that is where I think that we needed to amend our Section 6, which confers the judicial power of the state on the courts, not on the prisons. For instance, I don't see how the controller of prisons, whether the federal or the state, could determine what treatment or who goes to custodial or non-custodial. Yes. So I think it's important, and this is what we've done in Lagos State. Lagos State has introduced the restorative justice pre-trial diversion. And it is from that kind of system that you can deliver the outcomes, whether of community service, parole, or whatever. And that is where you are able, through that system of justice, which is, tripartite. What we have presently is state and the offender. But in the restorative justice system, you have this victim as a party, you have the offender, and you have the state. It is at that kind of interactive, therapeutic kind of judicial adjudication you are able to identify what is this guy's problem.
Okay.
And then you can begin to talk of treatment.
Let's take another break. When we come back, Mr. Ukumadu will still be telling us some of those areas that needs to, we need to look at and find implementation in terms of providing structures. To stay with us.
All right, so you're welcome again to Sunrise, and we're looking at the issue of the new prison reforms that has just been signed by the president. All right, so Mr. Madaki, I'm looking at the big picture here. This is a fantastic reform coming to the prison service and all of that. But if you look at the big picture, you'll see that now people need to be trained. Lawyers need to be trained. Lawyers need to be hired. We also, one of the big issues with the prisons is congestion. To avoid congestion, you also need to look at the fact that, okay, how do we incentivize people in the society not to commit crimes? We see that poverty is at the basis, is at the base of this. What is the national orientation doing about this? But if you look at the government agencies that have to work with the prison service, for instance. Some of these agencies don't even have generators to run. They don't have up-to-date computers and all of that. And then it comes down to funding. So you see snippets of people doing the right things in the right places, but who pulls it all together such that when decision is being made in Abuja, somebody can stand there and say, this X portion of the money we have has to go to prisons, has to go to corrections, has to go to National Orientation Agency. Who pulls it all together so that the people who have worked on this reform, who have done a fantastic job, their work will not go to vain?
Well, you could see that your question revalidates our concern that it mustn't stop at just the change in nomenclature. How to operationalize this has become by far more important than that aspect of change in name. And make no mistake about it, there are so many other aspects of the law now that deals with other aspects of the challenge other than the name. Now, having said that, it is that, look, it requires not just the training you talk about, issue of funding, issue of capacity building, issue of empowerment. And above all, there must be a synergy, a well-coordinated synergy that recognizes the importance of effective collaboration and interface between the state actors now, all the relevant, agencies of government that will bring about this change that is, expected to happen. My take is that, look, whether we like it or not, it is a whole package that has started not just with this correctional prison bill. If you look at the Administration of Criminal Justice Act, for instance, Section 34 of that act talks about the capacity of a chief judge, for instance, to designate magistrates within areas where you have detention facilities to make periodic visits. What is the purpose of the visit? Go find out whether there are unnecessary congestion there arising from the detention of persons who otherwise need not be detained. Review the bail conditions if they are, and possibly grant bails. Now, if you tie that to what is sought to be achieved with this bill, you will see that the picture is focused on the entire administration of criminal justice system that will be comprehensive. And I imagine that this is precisely why in some other jurisdictions, I'm sure my colleague will bear me out, South Africa in particular, the issue of sentencing is a different procedure in itself after conviction. You remember the Oscar Pistorius case? So, and then you need input from other agencies of government to be able to come to this desired conclusion that will reflect the state of our affairs in order to be able to maximize, as it were. So I make the point that, look, we cannot pay lip service to this. We have accepted that it is very innovative, very creative, but we cannot also run away from the original objective conditions that leads to the crime itself. A society that has become completely challenged in a manner that promotes criminality as a way of life, we have to deal with that provenance first, that beginning, that original aspect of our existence, before you're beginning to talk about what you do when it does happen. Because if you like, you change it to penitentiary homes, if you like, call it prison, correctional places. Once you have a groundswell of a situation that leads to crime in the first place, you will always have these congestions, you will have insufficiency in providing for prisoners, and then you may not be able to deal or achieve those objectives that you intend to get at. So just as we look at the aspects that have been identified, government must move faster now. If we did nothing about having the inputs of, for instance, I asked the question, to what extent can a trial judge, for instance, sentence an accused, well, again, they are called defendants now. That is part of the reforms, you know, just so to underscore their presumption of innocence. To what extent will a judge, a trial judge, convict a defendant, sentence him to 3 years imprisonment, or ask that he should be remanded there pending his trial, and then the prison officer says no? At the point where he makes that decision to say, no, we can't take him, are there alternative arrangements for alternative places of custody? Because much as you look at one side of this challenge and say it is good, the prison services is not just for correction, it is also for punishment, because at the heart of the entire justice process is to have this deterrent as a major factor to deter people from committing crime, and one of such ways of achieving that is to punish. So that society shows this resentment, that with respect to this particular behavior, the society resents to it and cannot condone it. So it's not just correction. Correction is to ensure that ultimately when you have served these sentences, you do not constitute a greater challenge to the society more than you were when you were right there. I've seen people who have written fantastic books, Nelson Mandela, many of the great political prisoners, written, some have passed exams, some have shown unusual skills and capacity while in prison. We understand all of those. But society also must show full resentment in punishment as deterrent.
Okay, let me go to Abuja. Uju, can you paint a picture of the state of a defendant, you know, in the prison, or as we call it now, the Correctional Center, and how the government can improve that state of that person, that individual?
First, yes, again, thank you for the question. First, please, I think it's necessary to clear some information. One, the notion of the non-custodial measures as in terms of the provisions, please, the law itself is not saying that the correctional service will be the one to determine who would serve non-custodial sentence. As the judiciary will continue to play that role, just like the judiciary decides who gets to be sent to custodial sentence, just like, you know, like the prisons. The only thing that this law is saying is that the supervision of those people, those who would then serve as probation officers, as parole supervision officers, and the things like that, will have to come from their ambit. And that's also why we find that this Administration of Criminal Justice Act and the Administration of Criminal Justice Law in many states, in terms of the provisions on non-custodial, have not been implemented because we have not had what this new law now have provided. Now, so it doesn't really need any constitutional change to start running. Now, in terms of the question about what is it that the different agencies can do to get a particular defendant, a particular person who is now in prison to be able to be fully taken care of. And I'm taking it now that this person is one who have been convicted of an offense, okay? Now, first of all, there are different reasons why persons commit offenses. And this is for this reason that it's necessary to do a risk and needs assessment of somebody that comes into the facility right from the beginning. So what that means is that you need to identify what are the reasons why this person committed this offense. So let's take, for example, you find out that this person have little or no job skills, or you find out that this person has challenge in terms of dealing with anger management. So what would then happen is that in terms of the programming, while the person is in custodial facility, those programming would dealing with things that will help the person maybe in building the skills, if that's the issue, in helping the person in terms of dealing with the anger management, in terms of people who are charged for violent or sentenced for violent and violent-related offenses.
All right. Thank you so much. Thank you, Uju Agomo, the founder, executive director, Prisoners Rehabilitation and Welfare Action, speaking from our Abuja studios. And of course, we have a legal practitioner and National President, Committee for the Defense of Human Rights, Mr. Malaki Ugumadu, and the Executive Director, Prison Fellowship of Nigeria, Benson Iwagu. Thank you all for sharing your thoughts with us this morning.
Thank you.
Thank you for the opportunity.
We'll take another break on Sunrise. Please stay with us.